Welcome to a special video edition of Rochelle's Daily Wire. As the name suggests, I'm Bill Rochelle, columnist and editor-at-large for American Bankruptcy Institute. We're coming to you from the annual meeting of the National Conference of Bankruptcy Judges in San Francisco. This is my guest, Susan Freeman, a longtime partner of the Phoenix firm Lewis, Rocha, Rothgerber, and Christie.
Correct.
Susan is counsel in what is, for my money, the most important case to be argued en banc in any circuit over at least the next 6 months and maybe all of 2017. I refer to the Sunny Slope case.
Yes.
Where, I'm sorry to say, Susan got her brains beat out with the panel decision in the Ninth Circuit. But if there is a God in heaven, something different will happen with en banc rehearing, which was granted in September and will be held sometime, I guess, what, mid-January?
The week of January 17.
Okay. I wish I could fly out to the coast to watch that argument. It should be a barn burner with what, 11 circuit judges? Is
11
that how
judges.
many sit? Because there must be 8 dozen judges on
Well,
the Ninth
28,
Circuit.
yes.
28,
So
okay.
too many for
All
all
right.
of them.
Yeah, right. In any event, here is what the Sunny Slope case was all about. It was the reorganization of an affordable housing project. Someone, a third party, invested $1,200,000 in essence to become the new controlling owner of the project. The lender was not wanting to go along with the project, instead wanted to foreclose. Now, I'm not going to give you the precise numbers here because they don't count so much, but let us assume that the value of the property as reorganized as an affordable housing project was about half of what it would be if the lender were allowed to foreclose. Because significantly in foreclosure, the lender would rid the project of all of the restrictions on affordable housing, which dramatically lower the rentals that you could charge for the project.
Correct.
So Susan won in the bankruptcy court.
Well, actually, I didn't win. The Engelman Berger firm won. I came in at the appellate level because I do a lot of appeals in addition to doing bankruptcy. But there was a great trial record that the Engelman Berger firm prepared.
In other words, you lost the case that somebody else.
I won at the district court.
Okay, that's good.
And then got a strong dissent, but lost Judge Clifton and Judge Kaczynski.
Well, that's right. Now, this case on the merits was all about valuation under the Supreme Court's 1997 decision in Rash. The circuit says that in the panel opinion from which you're getting re-argument, that you value the property based upon what the lender could do with the property in foreclosure,
Right.
not based upon the proposed use of the property in the plan. There was a vigorous dissent,
Right.
which I guess is the main reason we have re-argument en banc. Now, I'll never, Susan, forget the morning I read that opinion after it was handed down the night before. I'm reading the first paragraphs, and it says, this is a case about valuation of collateral in Chapter 11. And this goes on to cite several times in the opening page that the governing statute is Section 1325 of the Bankruptcy Code. Well, this was early in the morning for me, and I thought maybe there was something wrong with my brain because I couldn't understand how a Chapter 13 provision would govern a Chapter 11 case. Indeed, I guess it was just a plain mistake.
It was a plain mistake.
And the circuit issued a modified opinion just a few days later, substituting a reference to Section 1329 for the misreferences to Section 1325. But this has to go down as one of the more notable mistakes ever made by a circuit court. There is really two issues involved in your en banc appeal, and I want to talk first about equitable mootness.
Yes.
The panel was in essence bound by a decision in the Transwest case from the Ninth Circuit about a year before. So tell us what the equitable mootness issue is in this case, because very possibly they'll never get to the rash issue. It could go off on equitable mootness, could it not?
It could.
So tell us what the equitable mootness issue is.
The court said that investors were not the kind of innocent third parties that the equitable mootness doctrine was intended to protect. That's number one.
And by the way, there was no stay pending appeal, right?
That's correct. Well, there was initially a stay pending appeal, and then after the district court ruled in favor of Sunny Slope in large part, and it went back down, then an amended confirmation order was entered, and there was no stay pending appeal at that point.
Okay.
And at that point, it closed.
Plan consummated.
So, yeah, but that also means from the investor standpoint, they already had an appellate decision that the bankruptcy court was right on the valuation issue.
Okay, and the investor puts in $1.2 million, right?
And it was through a 1033 tax-exempt exchange. So the investors are going to take $1.5 million tax hit if this gets unwound.
Oh, wow.
And there's a substantial detriment to the investors. When the court said they aren't the kind of innocent third parties that the doctrine was intended to protect, they were looking at the Transwest case where the investors were competitors who were trying to ruin the company effectively.
But nonetheless,
and in our case, they were not. They were people who came in, an affiliate provided some DIP financing, but the only involvement that they had in the case was in providing feasibility evidence at the confirmation hearing.
Right.
So you had that aspect. The second aspect of the equitable mootness argument is that the court said that the state and the city, who were junior creditors here, were not to be protected either because they could protect themselves. And of course, and that they did not invest new money. But the fact that they negotiated treatment under a plan whereby their claims were stretched out as well, and they were to be paid in full at the end of the case after the first lien debt was paid, that didn't count. And then the third aspect of the equitable mootness argument that I think was wrong is that the court said you can unwind the entire plan. This was not the kind of scalpel directed to just getting rid of a third-party release, or something like that, where it's just carving out some little bit of a plan. Instead, the whole plan is to be unwound. And going back to Roberts Farms long, long ago in the Ninth Circuit, and really the equitable mootness doctrine everywhere, if you're going to slash the entire plan when there's been substantial reliance on it and money that's gone out the door to all of the creditors and new investors and new contracts entered into and so forth, that equitable mootness should protect that. So on all three counts, I think the court was just wrong in terms of its equitable mootness analysis.
Well, this is a big deal, I must say, Susan, because just on the equitable mootness issue alone, it seems to me this is a very good reason for potential buyers to stay away from the Ninth Circuit.
Well, it means that if you're going to be a buyer, you really have to be a buyer in a plan so that you get your 363M protection. But in terms of a normal reorganization and one like this, it really is nearly impossible if the investors are not to be protected. And one of the things we pointed out in our petition is that in other circuits, including the Third and the Fifth, you have case law saying that investors are the ones to be protected, because if you don't get investors, you can't get reorganizations.
Well, I suppose one could say that if you're in a position of a buyer worried about finality and being upset on appeal, you could always wait until appeals are completed. But, the Ninth Circuit...
That ruins the reorganization. Most of the time you can't wait.
Well, and particularly so in the Ninth Circuit, where getting through the circuit court by itself, without speaking of the district court, might take you 2 years or more.
Right. That's true.
And then you got to wait for the time to run on petition for certiorari to the Supreme Court. That will add another 3 to 6 months. Mm-hmm. Yeah. All right. Well, listen. Let's go on to the other merits issue.
Rash. Mm-hmm.
That is rash and valuation. What's the issue presented to the circuit court on rehearing?
Well, here the value of the property is impacted by covenants CC&Rs, covenants, conditions, and restrictions that require the project to be operated as affordable housing. And that means you can't rent it at market rates. So from the standpoint of the secured creditor, if the secured creditor foreclosed, it would be able to sell the property at a considerably higher price than the value under the plan. In this case, the secured creditor will be paid in full nonetheless because it exercised its 1111B rights. It's just going to be paid over 40 years, which it doesn't like. Surprise, surprise. But that's the normal time period for affordable housing. That's the tax credit time period. So it will get stretched out. It didn't like it. And I think the court really misunderstood and thought that the CC&Rs are not binding on the secured lender because the secured lender is in a senior position. But as we pointed out, I thought thoroughly in the briefs, but certainly in our petition for rehearing, the CC&Rs continue to bind until and unless there's a foreclosure. And that means they bind the secured creditor right now, and they certainly bind anybody who's going to buy the property from the debtor. And you look under RASH, you look at what the market value would be as the debtor is using it and as the debtor could sell it. And in both instances, it's as restricted.
Now, what's the legal issue, though? I mean, the secured creditor, as I recall, actually had a buyer lined up.
It did.
To pay substantially more than what I'll call the value under the plan. So what's wrong with that?
That's if it foreclosed, and then it would get rid of the CC&Rs.
But isn't that valuation foreclosure?
Well, no,
I mean,
it's not under RASH, and that's what RASH says. You don't value the property from the standpoint of a foreclosure that will not take place under the plan, and instead you value the property as the property is used under a plan and as anybody would buy it from the debtor.
Yeah.
And that's
now tell me, where
do
some of our reverend authorities come down on this, such as Collier on bankruptcy? Did the panel agree with Collier or disagree with Collier?
I think both Collier and Norton say that Chapter 11s like Chapter 7s, 11s like 13s follow RASH, and courts around the country have applied RASH in a Chapter 11 context. I mean, they might do it in a little bit different way so that they're looking at perhaps a little bit different rates, but they're really saying that you look at the value from the standpoint of how the property's used under a plan.
Yeah. Well, I think now it's clear why this is such a big deal.
It is.
It's an opportunity for the Ninth Circuit to state definitively where they stand on equitable mootness, and also valuation. And it's, like I said, somewhat jocularly, but not really so much so. The outcome of this case is really going to depend upon whether people put significant cases in the Ninth Circuit. I mean, in addition to this, you've also got the categorical prohibition against third-party releases in the Ninth Circuit, which...
Well, but you can get around that from the standpoint of a debtor by entering into a settlement and having the settlement approved under a plan. That's kind of the way we do it in order to make something work out.
Yeah, right. Well, it's awfully interesting, and I can't wait to see what happens. For your sake, I hope this is the end of the road, and I don't see you filing a petition for certiorari.
If we lose, we might file a petition for cert, and certainly if the bank loses, we can't tell whether it would file a petition.
Yeah, it does raise some rather interesting issues for the Supreme Court, especially on equitable mootness, which is, I mean, on equitable mootness, notably, that is a judge-made rule.
It is.
And there is an argument, courts pretty much always reject, that because the statute gives you a right to appeal, courts can't make up some doctrine to dispense with appeals. So, you know, it could be a cert-worthy issue.
Well, and they're looking to say whether an Article 1 court really should be the last word and whether you get Article 3 review. But here we got the Article 3 review from the district court.
Good point.
And although the Supreme Court denied review in Tribune on the equitable mootness point, ours is really a very strong case.
Yep. Right.
So we might be a better case for bringing that up.
Well, decisions often take a long time to come down in the Ninth Circuit, so if you're going to argue in January, it could be about this time next year,
That's true.
September or October, before we have a decision. Seeing as how they've got 11 judges, they got to line up on one way or the other. So Susan, thank you very much for your time.
Thank you.
We eagerly await your argument and the result in Sunny Slopes en banc rehearing.
Thank you very much.